So I got to move this somehow. All right. We're going to wind up with this thing right in the middle, I think. So let me see if I can get this framed a little differently. Okay. So from our perspective, the reason that this is critical is that this is a service industry, and as an organization that's been built on satisfied patients, satisfied referral sources, we understand that the patient experience meeting our expectations really starts with the staff that feels valued and appreciated. So this is the right thing to do. Why we move forward with management training is because managers have many responsibilities, but they really are the front line of risk management for us in a number of areas, including monitoring harassment. Gentlemen, if you could turn the mics off on mute, I hear a lot of background noise. So the intent here is to make you as an audience more aware of, again, the regulatory and legal climate. Also, the intent is to have you fully aware of what's expected from supervisors so we can support their efforts to be successful. Responding to complaints of discrimination, harassment, really, that's going to be driven from HR with my support as legal. A number of reasons for that.
Go ahead.
One is competency. One is competency in the investigation. The other is to protect the investigation through the use of attorney-client privilege. So managers and physicians should not be doing their own investigations, but rather involving HR and myself as counsel for the organization. All right. Again, if you can mute microphones, that'll make this a lot easier for everybody to get through. So preventing discrimination, harassment, and retaliation, it starts with setting the standard. It starts by demonstrating an awareness of the policy and a commitment to supporting it. And at the most active level, it's monitoring behavior in the office and reporting inappropriate conduct. Right. Again, stated a little bit earlier, but worth repeating. It's the responsibility of supervisors and physician leadership to make sure that these concerns are getting to the right channels, not to conduct independent investigations in the office. Question comes up, we'll get to the point later about where these come up and an individual doesn't want anything investigated, doesn't want to create an issue, doesn't want to create a problem for somebody. In the state of New York, knowledge of a manager or supervisor is imputed to the employer. And once there's an awareness of a situation, there's an obligation to take investigative and corrective action. All right, we know why plaintiffs sue. We talked a little bit about why this presentation is important. Manage risk, right? Not just legal and economic risk, but PR risk and a risk of having a dissatisfied staff. Key part of our policy on harassment is to protect discrimination, to protect staff from discrimination. But really, I think the key point on this slide is that concept of retaliation. And retaliation, in many cases, can be more severe than any underlying claim of discrimination or harassment, because typically that's where punitive damages are applied.
Downstairs.
All right, so a little bit of a test case, right? We have Joe here. He's a 27-year-old Caucasian male. The question is he a member of a protected class? And if you go back to the definition of harassment that we were talking about, it's essentially any discrimination on the basis of protected characteristics. So it's important to understand who has those protections. So is Joe a member of a protected class? Yes? No? Maybe? What are your thoughts? All right, I'll tell you. It's possible that Joe is a member of a protected class. Based upon 27-year-old Caucasian male, we know nothing about his sexual orientation, whether or not he's perceived to have or does in fact have a disability. A couple of areas that aren't commonly thought of, does he have a criminal record, right? In New York State and in New York City, you cannot discriminate against an employee by virtue of criminal record. cannot be singled out for treatment different than the rest of the staff based upon a criminal history unless they're related to the bona fide requirements of the position. Additional, engaging in protected activity, right? So if Joe is an advocate for recreational marijuana in the state of New York, we can't discriminate against them for that. All right? So equal opportunity employment. It means that they are entitled to equal treatment when making decisions on employment, employment-related decisions such as promotion, performance reviews, wage and salary decisions. Protected characteristics should not be considered except in the case of accommodation. Talked about this already. Facilitating
everybody mute their phones, please. It's very distracting, and I'm trying to listen. This is Craig Marcus. I'm muting mine. Everybody else do the same.
Thank you, Craig. So equal opportunity employment, and somebody's in the kitchen with a lot of background noise. They might have stepped away from the computer, but equal opportunity employment, basically if there's an issue, it needs to be reported. It's a responsibility that's a shared responsibility. Provided that the information gets to the right hands, these situations are seriously reviewed. They're not taken lightly, and there's a protocol in place for understanding the circumstances and making the appropriate correction. So the responsibilities of a supervisor are to take steps to understand discrimination, harassment, and retaliation, and then prevent it, appropriately respond to complaints by reporting it to HR, monitoring conduct, their own and others, for retaliation after complaint is made, and then facilitate an interactive process with any employee who might be making a charge of discrimination, harassment, might be requesting an accommodation based upon a disability, a pregnancy, other health issue, or some religious purpose. And again, that's not done independently. That's done through, become a pretty robust HR department over the last several years. All right, so harassment. It's not just sexual harassment. That's what people commonly think, but it's harassment that's directed against an employee due to any protected characteristic. It's, can be offensive behavior, or it can be more hostile where it's expressions of contempt directed towards an individual based upon a protected status. As an organization, we're not just concerned with harassment or discrimination that is legally actionable, but we're more proactive than that. We're taking zero tolerance policy towards harassment or discrimination, meaning that harassing conduct can violate our policy, even if it does not rise to unlawful conduct. Right? The goal here is risk.
Welcome to Ophthalmic Consultants of Long Island, setting the standard in eye care. We have more than 30 exceptional surgeons renowned for their clinical expertise, innovative care, and compassionate bedside manner. You don't have to live with vision problems for the rest of your life.
Disciplinary
Let us
action.
make it better. To meet our excellent doctors and staff,
Disciplinary action.
OCLI.net.
Send an email out. Maybe we can get this turned off.
For us, setting the standard in eye care isn't just a tagline, it's our mission, and we're proud to achieve it every single day. True pioneers of developing treatments and innovative technology, we combine emerging discoveries with the expertise of highly accredited physicians, changing the treatment paradigm in our specialty.
Behavior is not tolerated, will be investigated, and has appropriate disciplinary
We know what's important to patients undergoing cataract treatment: safety, accuracy, and predictability. That's why we pioneered and used the most advanced precision laser systems, which in comparison to traditional methods enhances all these aspects of surgery. We also believe in providing our patients with all the information they need to feel confident in their decision to move forward with cataract surgery. So find more details and even watch a video on how it works at OCLI.net.
Against a subordinate employee. That's referred to as quid pro quo.
If
It
you've
occurs
been
when a
diagnosed
person in
with
authority
diabetes,
with the
preventative eye
ability to
care is the
dictate
most
terms and
effective way of
conditions
avoiding and
employment
monitoring
engages
associated
and
diseases.
behavior that
Protecting your
rises to a
vision
level
is
that's
as important to us
unlawful.
as it is for you.
The
Please
situation
schedule
below,
your annual eye examination today. We'll be right
sexual
with you.
harassment is prohibited by the company only where there is demand for sexual favors, accompanied by
Up to 12 million Americans suffer from a disease called dry eye syndrome. And here at OCLI, we're committed to making life clearer and more comfortable for those people. Our patients will receive the best care available with the technology currently in place.
I'm going to continue. Sexual harassment is prohibited by the company only where there is demand for sexual favors accompanied by a threat of demotion or discharge, true or false. And the answer to that is false, right? That would be sexual harassment, quid pro quo variety, that's unlawful. But any harassment of that nature is not in line with company policy. Second type of harassment is what they call hostile work environment. Right? And in this case, what we're talking about is pervasive conduct that's offensive to the reasonable person. And in effect, it creates an environment where the ability to perform the work has been compromised. The test of whether or not a hostile work environment is legally actionable really comes down to that reasonable person. But again, as an organization, we're not concerned with preventing harassment that's legally actionable. We're concerned with preventing harassment that's in violation of our policy. So each element, and any element, whether it's unwelcome, based upon sex or participation or being a member of a protected class, any single element can be in violation of our policy, even though it wouldn't rise to actionable, legally actionable. So here's a pretty common situation, right? So I use the term honey or sweetie when I refer to a female coworker. One of the women complains about my conduct. My response is that I've used these terms for years and I really mean no harm. The question is have I violated the company's sexual harassment policy because I didn't intend to offend anybody? Would that be true or would that be false? Again, in this case, that's going to be false. The intent is not relevant, and even though this isn't pervasive, even though this wouldn't rise to the level of something that would be offensive to the reasonable person, it's still in violation of a policy because I'm not calling my male coworkers honey or sweetie, and I'm singling out individuals based upon their membership in a protected class. All right? So again, the difference is between what's legally actionable and what's in violation of our company policy. All right, here's a list of some examples, all pretty straightforward.
I put that new device in.
All right?
At 120, I was supposed to raise it all the way up.
I'm not sure whose voice that is. Eric, maybe you?
The Aquastat, the little black box.
All right.
Safety stick on there.
Next question.
Hot water heaters for hot water.
Female employee is asked every 2 or 3 weeks by a male coworker to go out for drinks. Female employee has politely declined, indicating not today, maybe next time. She's never reported the behavior. Any problem with this?
It's only going off to 120, shutting off.
And the answer is yes. Again, likely not to the level that's legally actionable, but does not square with the spectrum of OCLI policies on harassment. All right, so what that we're driving home is it's not just harassment that's illegal, that's prohibited. It's any disparaging remark or offensive conduct that's based upon membership into a protected category. Even if it doesn't rise to the level that's pervasive, it's still in violation of the policy. Another scenario, we have Steve and John, practical jokers, a little bit off color, frequently engaged in innuendo and sexual banter at work. No one complains. Most employees even join in, including Sharon. Yesterday, however, Sharon complains that she's been offended and has been offended for a while, and even though she's participated in this behavior in the past, she now claims that it's unwelcome. Can this form the basis of a harassment claim? And the answer is yes. And in this case, If it's pervasive enough and offensive enough that a reasonable person would find it to be creating an intimidating work environment, it's also legally actionable. All right? So I don't like to beat up too many more of these points. A couple of other key points, right? Who can the harasser be? It's not just managers and coworkers. It's not just supervisors. Patients, vendors, other members of the public, if they're frequent guests to our practices, can be the harasser. We have an obligation to our employees to protect them from outside harassment as much as we have an obligation to protect them from any internal harassment. Local delivery drivers, right? This is, again, a situation that doesn't quite rise to the level of harassment. That's going to be actionable. But to the extent that the advance is unwelcome and we're aware of it, again, the situation creates an obligation for us to intercede and make sure that it doesn't repeat itself. Other key point, it's not just the four walls of the office. It can extend beyond the office to someplace that's a company-sponsored event or even something that's private and off-site. Even can occur in virtual space, right? So if it's email, Facebook, texting between coworkers or between a supervisor and a subordinate, that can form the basis of liability for an employer. Not going to go through the next typo. And I guess this is a couple of key points, right? Harassment that does not violate the law but is disrespectful or unprofessional may still violate the company's policies. In particular, if somebody's singled out by membership into a protected class. One minor remark or inappropriate joke may not violate the policy, might not violate the law, but could very well violate company policy. This is a big change in the New York state law. It's not been tested by a court decision yet, but it's a point that's worth making. An employee who witnesses harassment but did not actually experience the harassment should encourage the victim to report the conduct, but should not report it him or herself. Any thoughts on whether or not that's an accurate statement or if that's a false statement? It's in fact, under the current state of New York state law, that's a false statement. Bystanders have a duty to report and can be held accountable for a failure to report. One of the things that the staff will get training on is recognizing offenses, how to step in or otherwise intervene, and their obligation to report on behalf of employees who may not be willing to come forward. Key thing there is for them not to do it alone. No such thing as a chain of command when reporting harassment. No need to take it to a supervisor first. Our policy contains multiple vehicles for reporting harassment, which would include C-level administration, such as myself, Tom Burke. It would include physician leadership, such as the Clinical Governance Board. It would also include the HR department. So employees may come to you as physicians with a concern. It's important, again, that you know your responsibilities there, which is to make sure that it gets reported forward so that it can be investigated.
Universal furniture.
So for staff,
one darker, one
in
lighter.
addition to the same means of reporting that you have as physicians, they also have access to an anonymous form through their time and attendance system and payroll. They all have Lindsay's contact information and mine, but certainly they'll also be encouraged to report to you as the physicians. So you should not be surprised if someone from time to time does come to you with one of these concerns. All right, supervisors, we talked about that earlier. They are our front line of risk management in multiple areas as an employer. They're required to report any harassment that they observe or is reported to them. It's been well-established law that knowledge of the supervisor is imputed knowledge to the employer, and if they do not act on those situations, employer liability likely does follow. It's not just, what they know, it's what they should have known. So there's no ostrich defense, right? If through reasonable prudence, they would have been aware of the situation in the workplace. They're also responsible for reporting those and having those properly investigated. Supervisors that do not report harassment that's been discovered to occur put themselves in jeopardy and would be subject to progressive discipline. That may include further education, but depending on the circumstances, it could include anything up to so key yardstick to judge behavior is not whether or not the behavior witnessed offends you, but does this conduct have the potential to hurt coworkers, particularly those of the opposite sex, a different race, a different religion,
Does it look anything alike?
or protected status. All right? So unwelcomeness is determined by the recipient of the behavior, not by the intent, but it's really a matter of the impact as opposed to the intent. Hey, Glenn, I think I hear you, Glenn Stoller. I don't know if you hear me. I think I hear you. All right, our goal, all of us together as physicians and as administration, is to have employees confident that as a company we stand behind them, that we're going to resolve these situations and support them, right? We want staff that can come to work, be confident in what they're doing, be comfortable where they're doing it, and feel like the respect that they have for you as physicians and hopefully they have for administration runs in both directions. There's a very practical reason why this is our goal, because again, it's well established, at least at the federal level, that if we have effective policies on dealing with harassment, employees can't run outside to the court system first. The court systems will direct them back to use the internal protocols and policies that the employer has in place. All right, so that's really, I guess, the primary reason for having these policies, in addition to, just that they're the right thing to do. So,
How is it? Good?
Key things, right? Person comes to you with a complaint, let them know that you appreciate their sharing it. Reiterate the company's commitment to foster a workplace that's free of harassment and a place that they can come and be comfortable and make a meaningful contribution. Listen, I would suggest is not the time and the place to be soliciting a lot of information. Listen enough to be sensitive and be impartial. Most important thing is to get enough information to HR so that the investigation can be commenced. To the extent that the employee coming to you is willing to go to HR directly, that should be the first step. You'd like to have them willingly participate. But to the extent that they're hesitant for any reason, the investigation still has to be commenced. All right? No such thing as an off-the-record complaint. Once a complaint is made, there's a legal obligation to investigate. We take every step reasonable to maintain confidentiality, but there is certainly an obligation to share that information with those that have a legitimate need to know. Again, one of the reasons why I should be involved in all these investigations is the information that's obtained there can then be protected by attorney-client privilege, which is a further and another risk management tool. So, how does HR handle complaints? Well, once they receive the complaint, they undertake the investigation. They're going to ask if there's witnesses. They're going to ask if there's evidence. They're going to take some statements. Generally, the first intake is with the employee making the complaint. Before any witnesses are generally spoken with, the next person that's spoken with is the person that's accused. If the accused individual basically validates everything that the accuser has shared, then there's really no need to speak with anybody else. We have to balance the need to do the right thing as an employer with privacy rights of the individuals that are involved, right? So an investigation is done as in limited fashion as possible to get to a reasonable conclusion. At every step along the way, the policy of non-retaliation is reinforced. HR will not dismiss the complaint, will not attempt to explain away the conduct. All these are the steps that and the things that you want to avoid. Talked about the investigation and how it will occur. Mentioned this before, there's no such thing as an off-the-record complaint. These are some common excuses that staff accused of harassing behavior sometimes share. None of them are really valid. As an organization, our policy on non-retaliation is pretty specific. New staff get it as part of their new hire orientation. Established staff have had awareness of this. It's circulated periodically. It'll be reinforced during the staff training. Any retaliation for reporting in good faith is strictly prohibited. It's not uncommon, and I've been a part of a number of conversations on this. Employers frequently prevail on the underlying claim of discrimination or harassment, and then frequently lose on a claim of retaliation. And if those retaliation claims that sometimes are more costly than the underlying discrimination claims, because again, that's typically where punitive damages become awarded. All right? So retaliation can take many forms. It's not just bad reviews. It can be as minimal as becoming the outcast in the workplace. And that's a particular challenge for an organization, right? Employees lodge a concern, investigation has gotten done. Somehow along the way, word has gotten out, and now they're singled out for treatment by their peer group. And that also could be considered retaliation. All right? So a couple more hypos, and then we'll bring this home. Right? So Jane and her husband Paul both work for the company. Jane has complained to HR that her manager's sexual comments would make her uncomfortable. A couple of weeks after the complaint is made, Jane's manager terminates Paul's employment for no stated reason. Could that conduct be seen as retaliatory? The answer is obviously yes. If you have the slide deck, there's some additional resources to get some additional information. The one that should not come as a surprise is that it's not at all uncommon for the police to get involved, because if you have a touching, you basically have an assault, and that's a criminal offense in addition to an act that's actionable from employment law standpoint. All right? So some hypotheticals. George is a supervisor, right? Not uncommon for him to lose his temper and yell at staff. He yells at both the male and the female staff. Question: would George's conduct be considered unlawful? It's harassment. Is George just basically an equal opportunity jerk and harasser, but not violating the law? Is his conduct otherwise fine, or none of the above? And I'm not going to pick on the two people that I can see watching, so I'll give you the answer. The answer to this one is big, all right? It's not a violation of the law. Yes, George might be an equal opportunity jerk, but there's no law against being a jerk, right? Ella has supervised Mariana for 5 years. They've always had a good working relationship. Ella finds out that Mariana is actually bisexual orientation, a lesbian, has a female partner. They get back to work the next day. Ella lets Mariana know that she does not support gay marriage because homosexuality is against her religious beliefs. Are those actions inappropriate? And in fact, they are, right? Ella should not have commented on the personal life. She's entitled to her religious beliefs, but she should not single out or negatively treat somebody based upon them while at work. Last typo. So we have Eva, attractive female employee, dresses provocatively in blouses, necklines, short tight skirts, high heels. She walks down the hall, male and sometimes even her female coworkers stare at her and have reactions. Those reactions range from whistling to shaking heads. We even have Joe here who acts as if he's having a heart attack when she walks past. Eva has repeatedly told her coworkers that their conduct embarrasses her, and she's even asked some of them to stop. She's had no success. Some of her female coworkers mentioned that she's part of the cause of her own problems by the way that she dresses at work. Question: are the employees engaging in harassment? And the answer there is yes, in fact, they are. You may have more than one violation here, right? Eva might be violating the company's policy on professional attire, in which case the supervisor should be managing that issue. But that violation of policy does not excuse the behavior of Eva's coworkers. Okay? And I think that gets enough of the points home. Let me get to the key takeaways, right? So, as the position leaders of the practice, right, you want to make sure that you're setting the standard in the office. This is really directed to the supervisors, so I want you to view this slide in that context. But I could ask for your assistance in monitoring the behavior of the supervisory staff in the office. Is it respectful? Is it professional? Monitoring their behavior to make sure that they're not engaged in unwelcome sexual advancements or any protected category-based conduct. I don't know, and I'll get this circulated right after the training to all the physicians, both policies on harassment and on non-retaliation. So if you haven't seen them before, you have access to a copy. But I would ask that you understand those policies. There's opportunity to ask questions either of me or other members of the HR staff to get clarification. But as you understand those policies, make sure that the supervisors are enforcing them, either as physicians or indirectly. If supervisors come to you with concerns, support their reporting of these complaints and incidents to HR as soon as possible. One of the new changes in the law is that there's generally considered a 30-day timeline from the date that an incident has been reported to conclude an investigation.
Jack is here. I don't think he's
get
leaving
to some
without his
decisions. Circumstances come up, whether as physician or as an office leadership team, the need to cooperate with investigators, and understanding and reinforcing that violations of the EEOC policies, the discrimination, non-harassment policies, or the retaliation policies will result in corrective action up to and including possible termination. All right? And at this point, I'll open it up for questions. Any questions?
That was superb.
Good job, Tom.
It was
Good
Reader's
job.
Digest version, and I appreciate those of you that had the microphones on mute for the duration, because that was a tug-of-war for sure.
God.
All right,
Tom,
if you have any questions,
Tom,
feel
thanks
free
for
to ask.
organizing.
Thanks,
No
Tom.
problem. Harlan, are you on, or Sabrina? I think there's a inbox in HR that's been set up to receive questions and respond. Is that accurate?
Yes, we have one set up. It's the sexual harassment Q&A, and we're going to be setting up a hotline as well.
Yes, and those Q&As after if hopefully we get some, right? Those Q&As will be circulated to all staff just so that they have, yet again, a little bit more of an opportunity to gain some insight here. So I thank everybody for their time and attention tonight. I look forward to seeing you in my travels, and I hope everybody's having a great start to 2019. All right?
Thank you, Tom.
Thank you all. Bye-bye.
Thank you.
Thanks, Tom.
Bye-bye.
Thank you.
Thanks, Tom.
Thank you, Tom.
Appreciate it.